is October 1st is a new year for the USCIS, and there are extra 110,000 green cards that are available. Approximately 110,000 green cards are available from the family category that will fall into the employment-based category. In addition to the 140,000, so it may be up to 110, so we're expecting 250,000. Particularly for Indian nationals, they have been backlogged because of the per country quota. A lot of people were expecting some miracles because there are not many people who are waiting in the list, so most of the 110,000 green cards should be going to the Indian nationals though. And now we are waiting. What priority date? The visa bulletin used to come on 9th, 10th of the month, and now we are 22nd and we are at 5 o'clock Central Time. It still doesn't come. What's the mystery?
I personally don't think there's any conspiracy. I think it's just they're not too concerned about giving people advance notice. It's not a very pro-immigration, immigrant-friendly administration. They don't really care if people need time to prepare. I think it's just they'll put it out when they put it out, and there's no reason behind it.
I think so. I'm not expecting a conspiracy, but I think so. There may be a disagreement between the State Department and the USCIS.
But that's why you have the two charts. USCIS can always say, no, we're not going to use
the State Department can move the final action dates chart much further, and the USCIS may not want it though. There are a lot of speculations on this. People are going wild and saying that, oh, EB2, EB3 is going to be current. What are the probabilities, Emily?
Yeah, I just don't see that happening. Yes, we have a large number of green cards available, but the number of people in the backlog, looking at year after year, over the last 10 years, how many PERM approvals are there for Indian nationals? It's like 50,000 a year.
Right.
And that doesn't
include the family members.
Now, yes, some of these may be duplicates. There may be people who file more than one PERM, more than I-140 as they move from job to job to job. But that is counteracted by the number of people that have family members that would also be filing. I just don't see it moving to current.
No, I don't think so. It's legally possible, at least if you look into the numbers of 110,000, even if you give the 110,000 green cards to Indian nationals though, it's not expected to be current at all. So please don't be under the hope that it's going to be current. As Emily was pointing out, approximately 50,000 people Indian nationals are filing labor certifications every year. And then we did the calculation. We have the numbers. We put it on our website from 2010 onwards. Now, remember that the priority date became current all the way to May 1st of 2010. This happened in 2012. So not many people whose priority date before May 10th are left over. It's only after May 1st of 2010 are the people who have been waiting. So that's where the people are more tensed up. What is your guess on? I have gone 10,000 times wrong in guessing. I don't know if there is any lawyer who has gone wrong 10,000 times other than me, Emily. So I take the blame, but what is your guess?
Oh gosh, I don't even know if I want to put a number out there because it's just going to be wrong, and I don't want to give false hope.
There are certain things that we have a little bit better estimate. I would say that the EB1 category should be current for all nationals. That is one of the guesses that I take. The EB3, rest of the world, that does not include the Chinese nationals and Indian nationals, should be expected to be current. We are expecting the priority dates for EB2 and EB3 to be moving forward. There is a chance, Emily, my suspicion is that EB3 might move a little bit more forward for Indian nationals. That's my suspicion. EB2 should be forward, but with regards to the guessing of it, please, it's your guess is as good as my guess, and I can tell that your guess might be better than my guess, because remember, I have gone wrong 10,000 times. Most probably you have not gone wrong 10,000 times in guessing the priority date. So in guessing the priority date, you may be as good as I am. I mean, it's very confusing to do. Let me tell you one thing. In March of 2012, the priority date was EB2 was May 1st of 2010. In August of 2020, guess what? The priority date backlog. So the maths and certain things that you think about don't work properly in guessing the priority date. And so that's the reason I take the blame. Anything else on the there's one thing, Emily, when the priority dates have been issued, there are two dates. One is the final action dates, one is the filing dates. Can you explain what the difference between those things are? And when do you expect the USCIS to come forward on that?
Yeah, so the filing date and final action date has been around for 5 years, and we still don't have a good handle on using it properly because we're still getting this whiplash of dates moving forward and backward and retrogressing and not, and which months USCIS will allow us to use the filing date versus the final action date. Generally, the first month of the fiscal year of the last 5 years, we have been able to use the filing date. So what's the difference between the two? So the filing date is a prediction of what Department of State thinks the final action date will be by the end of this fiscal year. So they're predicting that by September of 2021, this is where the final action date will be. And they put the filing date there so that USCIS, if they choose to let us use it, they will be able to generate people filing and start working on the cases, since it takes a year to process the application, so that they can use them up throughout the year and end up with no green cards wasted by the end of the fiscal year. That's the whole purpose of the filing date, is it allows you to file early so that USCIS doesn't waste green cards by waiting until your final action date is current, and then they run out of green cards before they run out of time. Because if you don't use all the green cards for employment based by the end of the year, they are wasted, they're gone. You don't get those back. It's not like the family where they spill over.
Emily, what's going on anything else on the visa bulletin that you want to add, Emily?
I don't think so.
Emily, what's going on the I-129 form? I mean, there's a new form that we needed. If we file an application on October 2nd, there's a new form, and they haven't released the form. Did they release the form, or what is it?
Kind of. So finally today.
What do you mean, kind of?
Yeah. They posted on the USCIS website, on the forms page, a preview of the new form. It says preview all over it, and it says that it could actually change before we get the final form. So it's not exactly the final form. So the big change is, the I-129 is used for many, many different types of non-immigrant work visas. H1s, L1s, TNs, E-visas, OOP, QR, the list goes on. And so from October 2nd, they're actually splitting up the form into multiple I-129 forms that are specific to each visa category. So if you're filing an H-1B, it'll be the I-129 H-1 form. If you're filing an L-1, it'll be the I-129 L form. If you're filing a TN, it's going to be the I-129 E and TN form. Those are combined, and then there's kind of a miscellaneous form. But that kind of goes along with the fee increase, because the fee increase changes the filing fees based on visa type, which is the first time it's been like that in quite a while. So now there's a different filing fee for H1s compared to L1s compared to O1s. So all of that combined, this new version of the form has to be used if you are postmarking your application on October 2nd or after. So yes, the new form is available, but it says preview all over it. You can't use it yet. If you mail it tomorrow with the new form, they're going to reject it. If you mail it tomorrow with the new fees, they're going to reject it. If you mail it on October 2nd with the old form, they're going to reject it. And if you mail it on October 2nd with the old fees, they will reject it. So the next week or two is going to be very careful. You have to make sure that your petition is being filed on the correct version of the form with the correct fees based on exactly when it's being mailed out, not received by USCIS, which is normally the rule. Now it's based on postmark.
Yeah, that's surprising. This is very nightmare for the people, especially if their visas are expiring or something like that. They got a new job, they can't move to a new job. This is confusing. This administration is doing, I believe, intentionally conspiring against immigrants. That's the feeling that I get, Emily. Emily, with regards to the Trump administration has recently sent some interim regulations to the Office of Management and Budget. It seems that there are some restrictions on the H-1B, employer-employee relationship, specialty occupation, and also wage level also. What's going on this one, and what is Trump trying to do right now?
Yeah, it seems to be kind of a last-ditch effort before the election for him to tout to U.S. workers under the Buy American, Hire American, look at all I've done to protect U.S. workers and limit immigrants from stealing your jobs. That's basically what he's trying to do as far as his election campaigning. So we've known these regulations were coming. What's different is for the I-129, H-1B, specialty occupation, employer-employee relationship regulation, they're going straight to an interim final rule rather than doing a notice and comment period. Same thing for the DOL. They didn't even have it on their regulatory agenda that they were going to do anything with wages, and all of a sudden they're issuing an interim final rule to OMB for their approval. So they're trying to fast track these two regulations. So I expect they'll probably come out before the election. And it's all designed to limit the number of people here on work visas and show that they're buying American and hiring American and all of those sorts of things, and that Trump followed through on his plans. But overall, I mean, it's really just, it's going to be making everything more restrictive, more difficult, higher level, higher scrutiny to get an H-1B approval, even though the statute set by Congress has never changed.
Emily, there are two things that I'm hearing right now. One is that there is a proposed regulation that has been issued by the Trump administration that may require H-1Bs and L-1s to have the biometrics done. And maybe DNA is also done for some of the people. I don't know what all the medical tests that they can do for giving a H-1B are. Now, then on the I-129 form that's going into effect on October 2nd. The regulations are not becoming effect on October 2nd, but the I-129, they're telling that these H-1B people or the L-1 people, when you apply, they can be called for biometrics.
Yes, and that's an important distinction, is there are two different things. So we have the biometrics regulation, where we have a proposed regulation that's hundreds of pages long, talking about requiring the U.S. citizen sponsors of green card applicants to submit to a DNA test and do fingerprinting and all of that. This is separate. This has nothing to do with that regulation. It's not going through any kind of notice and comment. It's there in the instructions to the new I-129 form. So if you go to that preview form on the H-1B or I-129 page on the USCIS website and click on the I-129H instructions, it says that anyone who's filing an I-129, USCIS can call you in for biometrics. That's exactly how they did it when they implemented the I-539 biometrics. There was no biometrics regulation. They just snuck it in a form update into the instructions, and now we've been stuck with it for the past year and a half, and that has caused so many issues, partly due to the COVID situation, but so many delays in adjudicating H4s and L2s and F1s and B2s and B1s because of this biometric requirement. What is it going to do to H1 processing, L1 processing? How is it going to impact premium processing, which is already going to take longer beginning October 2nd? And when the I-539 came out with biometrics, they specifically said, we will no longer approve the H4 with the H1 in premium because we can't get the biometrics done in time. So now are they going to be able to get it done in time for the H1 to file in premium?
So what's going to happen with the H1s? Is it going to be the same thing like H4 nightmare, like 18 months of time sometimes to get a H4 approval now?
Yeah, it's anybody's guess right now. We have fewer employees of USCIS because they still have their budget problems. They
have a budget problem because of all these implementations.
Right. Oh, yeah.
What they're doing.
Mm-hmm. Yeah.
Let's go to the question and answer assembly. A lot of questions are coming with regards to the prediction of the prior to date, guys. As I said, I've gone 10,000 times wrong. Your prediction is probably better because you haven't been wrong 10,000 times like me. So please, please excuse me on that. Questions that are coming are with regards to the H4 EAD delays. Yes, they are getting delayed a lot. And Rishi from Facebook has this question, is that H4 EAD delays, what can be done? There's a litigation process. If you want to join us, you can send an email to info@rnlawgroup.com. We'll give you the details of those things to you. And we do conduct a conference calls for the H4 EAD delays every single day at 11 o'clock. It's a free conference call. You guys can attend. I will give you the conference call information. It won't be there right now, but I'll put it later on at the bottom of it so that you guys can call the conference call information at 11 o'clock just for H4 EAD delays.
A couple of people had a question about filing an H1 transfer while you have an H1 amendment pending. This is Arvind and also Saranya on YouTube had the same question. So in general, we've not had a problem with that. So assuming that your underlying petition is approved and still has validity left on it, and you have filed an amendment that's pending, you should be able to file a transfer regardless of the outcome of that amendment.
Ayer from YouTube has this question: if one party gets a supermajority in both, assuming a majority in the House and 60 seats in the Senate, can they pass the Senate 386 bill? First thing is, the problem is that right now, when I look into the real clear politics, and I'm not going to take which side of the party, no party is aiming to win 60 Senate seats right now. They're not even trying to win 60 Senate seats right now. They're not even putting their money and their effort to win the 60 seats. So that doesn't look possible right now. At least in these elections, it's not possible. Maybe the next midterm elections, we can look into that 60. So even if it is a 60 majority, though, to pass the Senate 386 bill, there must be a will from the administration. It looks like the Senate 386 bill has the 60 votes in the Senate. The problem is the Mitch McConnell, the majority leader there, he doesn't want to put it there. He wants all the senators to agree upon. Come on, that's not going to happen. So he can put, if he puts the Senate 386 bill, it will be passed with the 60 easily. I have no doubt that will pass, but he's not putting it. You can put a pressure on him, because what is happening is that initially it was the senator from Georgia, then it was a senator, it was a senator from Rand Paul from Kentucky, then it was a senator from Georgia, then it is a senator from, Democratic senator from Illinois, then now we have a Florida senator. It just keep going on and on. I mean, why can't he just put it out, vote, let them vote, even if it's getting defeated, put it out there. He's not putting out there, but I would still recommend people to put a pressure on the senators and the congressmen to get the Senate 386 bill passed. And when you request the senators or the congressmen, please don't tell that this is giving benefits to Indians or Chinese national. This Senate 386 bill is not giving any special benefits to Indians or Chinese. It is only telling that everybody should be treated equally. It's not giving any preference to Indians. Everybody should be treated equally. That's all. When you approach them, I should be treated equally, just like any other human being coming from anywhere. Just treat me, nothing special. That's all you should request.
Smart Coder from YouTube wants to know how all of these new regulations and biometrics that we've talked about will impact a pending application. So his was already filed July 16th and still pending. We don't expect it to have any impact on pending applications. Generally, whenever a final rule is announced, it will have an effective start date that's usually 60 days in advance of when the rule is published, and it takes effect for applications filed on or after that date. So it shouldn't impact current applications.
Question that comes out is Rahul from Facebook has this question. The new rule 944, if somebody has a non-working spouse, will that affect in immigration process extension? Rahul, in general though, this 944 should not affect the business immigration. If your family income is more than $60,000 a year, now, unless you're some gambling addict or something like that, there are always exceptions though, okay? There are always exceptions, but if your family income is more than $60,000 per year, it should not affect your extension, transfer, or eventually getting the green card. It should not have any problem. The 944 should not have any problem. There's also a lot of questions that are coming up in the 485 application. Do we need to include the 944 application right now? There's been a lot of back and forth between the courts. First, Illinois court said something, and the New York court said something. My rule is only one thing right now. Include the 944 application when you're filing the 485. If you don't, there is a good chance your 485 will be thrown out.
Yeah, and USCIS did update their website today, confirming that they will apply the public charge rule to anything filed after February. So if you filed without it previously, now you're going to be asked for it.
Now you have to go and file that application for 944.
Lakshmi from Facebook wants to know what happens in a situation where you got a change of status to F1 approved and then an H4 extension approved after that. So it really is a gray area. There's kind of two competing ideas here. The first is that once your status got changed to F1, it's technically not possible to extend your H4 since you're no longer in that status. So that's one concept. But the other concept is the last action rule that normally says that the last I-94 issued is the one that controls, which would be the H4 extension. So there's not really any guidance on that. The best thing to do would be to travel and then enter on whichever status you want to be on so that you can be clear that get another most recent I-94 under the last action rule in the status that you want.
Ozzy has this question about the delay of the visa bulletin. This kind of delay, have you guys noticed it before? I've been practicing immigration law from 27 years, 25 years, 27 years. And I've been an non-immigrant, and I've been watching the visa bulletin since the time that I came into the United States. So, no, I have never seen a visa bulletin not getting released until 22nd of the month, though. There are some issues that happened in 2007 where they issued a visa bulletin and they corrected the visa bulletin later on. That happened a couple of times though, not just June of 2007. There are a couple of other times where they issued the visa bulletin and they said, no, it's not there anymore. But not the issuing of the visa bulletin until 22nd. I have never seen it. I don't recall at any time that happened.
Gopi from Facebook wants to know if we can clarify on dual employment, working for two employers while on H1. That's called concurrent employment, and we actually have a separate video just on that topic that you can find on this YouTube channel. So if you check that out, we thoroughly covered everything to do with concurrent employment there. And yes, it is possible on an H1.
This question, Vishwas has this, can I do two jobs with one single H-1B visa, two full-time or one full-time, one part-time? Well, the job is only one, and what you're ignoring is that the job you're doing is for your H-1B company. If they have two different end clients, okay, then that doesn't mean that they are two different jobs. Your employer is A, and let's say, for example, if you have a client called AT&T, and then you want to add another client called Coca-Cola, your job is still with the same company that is giving you the salary. To have two end clients is still considered the same job. For example, if Emily is there and she is processing for one company and she's working for 10 different companies at the same time with Reddy Neumann PC. Her employer is Reddy Neumann PC, not the clients that she's working for. So if you want to add many clients, there is nothing wrong with it. You just need to be in coordination with your company that is employing you. Nothing wrong with it. Can you work for 80 hours with your company? Yes. In that 80 hours, can you have 2 clients? Yes. Can you work for 40 hours for one client and 20 hours for one client? Yes. Please check with your company and they should be happy to have you work, and we like your taxes. Please pay taxes.
Amarnath from Facebook wants to know if it's possible to transfer an H-1B that's beginning on October 1st of 2020 if you never worked for that employer. It may be possible. We do that quite often. We file it right on October 1st or within 60 days under the 60-day grace period. But it does depend on the original H-1 approval. Number one, it should have been as a change of status, not consular processing. And number two, it should have been a valid petition at the time of filing and at the time of approval, meaning that if it was from an in-house project consulting company that really didn't have a project and now you are on your own trying to find a job, that petition may be problematic for you to transfer to another employer because it could be revoked in the future.
There are 2 good questions coming from YouTube, one from Jay and one from Vikas on the 485 application. The first question is that if the 485 has been, and if the 485 and 765 has been filed initially, and if the visa expired, that means that either their L1 or H1 expired, can they continue working based on the 765 application pending? The answer is no. You cannot work when your 765 is pending, because there is an exception that's available that if you're filing an extension of the EAD application, though, the rule is that you can work up to 180 days. But when you're filing an initial application of the 485 and 765, you cannot work based on the pending application. You have to stop working if your work permit expires. The next question is from Jay, is asking how long it's taking if we file for the adjustment of status to get an EAD card. Good question. It used to take 3 months before Trump administration, and now it's taking about 8 to 10 months to get an EAD in advance parole once with the initial application.
Rajiv from YouTube wants to know what happens when you have an approved I-140 that's been approved for at least 6 months and then you exit the U.S. because you lost the job. Is there a way to come back in the future? So I'm assuming that you were in H-1 status, and so you've already been counted in the cap based sometime in the last 6 years, or even beyond that, and are using the I-140 to get continued H-1 extensions. And the answer is yes. Another employer or that same employer can file a petition for you without going through the cap, since you've already been counted, and use that I-140 to get a 3-year H-1B approval in consular processing. Once that gets approved, you can, if you already have a valid visa stamp, use that visa stamp to come in and start work for the new employer, or go for stamping if you don't have the valid visa stamp.
Prem has this question, is it a good idea to downgrade because EB3 is projected to go forward than EB2? Prem, don't do that right now though. You can do it when the priority date becomes current. Now you may ask a question, when it becomes current, well, I might not be able to file the adjustment of status. If you file a conversion from EB2 to EB3, at the same time, you can file the adjustment of status. You can attach the adjustment of status application to the downgrading of the application. That's the reason I'm telling you not to do it right now. You can do it at the time when it becomes current under EB3. It'll be waste of energy, waste of money, and you will be in a loss if you convert it before it becomes current. Prem, it's a good idea right now to check with your employer, because I know that some of the employers are not willing to downgrade and file the adjustment of status. It's good to check with your employer. Ask the employer, is it okay? Would you be willing to downgrade from EB2 to EB3 and file the adjustment of status? And please check with them. Now, for downgrading from EB2 to EB3, you don't require a labor certification. You can use the existing labor certification and downgrade it. That means that the labor certification that you used for the EB2 can be used for EB3 for downgrading. Absolutely no problem. We do that very many times, had never faced any problem in downgrading from EB2 to EB3. Now when it comes to upgrading from EB3 to EB2, most often it requires that we must file a PERM labor fresh again. But in the case of downgrading from EB2 to EB3, it's not a problem at all. It's as easy as, can I call a billionaire a millionaire? Yes, you can. All billionaires are millionaires, but not all millionaires are billionaires. That's how easy it is to downgrade from EB2 to EB3.
Kapil from Facebook had applied for a change of status from H-1B to B-2 due to job loss, and the B-2 of course is still pending because they're taking forever, and the 6-month stay requested on that B-2 is almost up. He wants to know if you should apply for another B-2 extension. So if you're not able to exit the U.S. by the time you get to the 6-month date that you requested in your initial application, that really is your only option. Normally, pre-COVID, I would never recommend filing a second B-2 extension, but we're in unprecedented times, and that's really the only way to continue to remain in the U.S. And be lawfully present. It would be to file another one.
Prem has this question. With an I-140 approval more than 180 days and not been withdrawn, can he use this I-140 approval to move to a different company? Yes, you can, Praveen. You can absolutely move to a different company using this one. Not only you can do that, if you want to move, you can use a company A's I-140 to move to company B. From there, you can move to company C using company A's I-140. The condition is it must not have been withdrawn before 180 days after it's been approved, and it must not have been withdrawn before January 17th of 2017. If both conditions are met, you can use that.
Raju from YouTube has an H4 to H1B application in progress. There was an RFE involved on that, and wants to know if you can also request an H4 extension as a backup. So assuming that the H4 has not expired yet, yes, this is a good idea. No problem in doing that because, yeah, if your change of status to H1 gets denied and at that point your H4 has expired and you did not file an extension, you're immediately out of status and begin accruing unlawful presence. It's not really possible to go back from that. So yes, you can file an H4 extension even though you have an H1B change of status pending as a backup plan.
A lot of questions are coming on the EB2 to EB3 downgrading and the effect on it in filing the adjustment of status. We have a separate video that we presented it. I'm going to put the link after in an hour or so in the YouTube and Facebook for that YouTube link. You can watch that. It's just made on downgrading from EB2 to EB3.
Praveen from YouTube wants to know if you have the approved I-140 for more than 180 days, are there any restrictions on applying for extensions with different employers? Assuming that the I-140 was not withdrawn within that 180-day period and wasn't withdrawn before January 17th, 2017, there are very few exceptions to being able to file that extension. You can file it with employer A, with employer B, with employer C, and get a 3-year approvals every time, assuming that the employer has a valid job offer for you until the priority date becomes current. Once the priority date is current, you're only eligible for 1-year extension from that point because they expect you'll be filing the 485.
Nitya has this question. If the priority date becomes current, if the employer is not going to supply with a 485J supplement, can we file the adjustment of status right now, and then can we provide the 485J supplement later on? The answer is no. If the 485J supplement is not included along with the 485 application, the adjustment of status will be denied. The only exception that's available when the employer doesn't need the 485J supplement is if you are filing an I-140 application along with the 485 application, at that time you don't need a 485J application. For example, if somebody is downgrading from EB2 to EB3, they're filing an I-140 application and they can file the 485 along with it. They may not need the 485J supplement. For example, if some persons are not born in India or China, their priority date is current, and especially if they're an EB2 and they're filing adjustment of status based on the labor certification, filing an I-140, at that point of time, you don't need 485J supplement. But in your case, you need the 485J supplement. If not, we cannot file the adjustment of status.
Ram from YouTube wants to know, with the current 485 processing times at the various service centers, will USCIS be able to utilize all of the employment-based visas allocated in the upcoming fiscal year 2021? That is a big risk, honestly. I mean, we talked about that at the beginning, that's the reason, part of the reason why USCIS allows these filing dates to be used, so that they can actually have enough time to process them. They do, from time to time, I don't want to say make adjustments, but they will grab a visa number and assign it to an application and use that in the future, even if later it looks like they ran out of green cards or they ran out of time. So I think that they probably are, going to be very careful about that to make sure that they don't waste green cards, because there will be a huge backlash against USCIS for that. So hopefully that's not something we have to worry about.
Vishwak has this question from Facebook. When can we expect India to start processing the stampings in India? We don't know. That requires a little bit expert on the COVID and this administration. This administration says they want to open everything and they want to run everything, which they are. But when it comes to the consulate issuing the visas, they are not. So there is definitely a partiality in the way this administration is acting on immigrants. If they want to open everything, I mean, when I go to the National Forest, everything is open. They're opening everything. Why can't they open the consulates? They're intentionally doing. That's how the things are right now. One thing is there, that at this point of time, there is a drop box. If you are eligible for the drop box is functioning very efficiently right now. In fact, the drop box, the eligibility, they have expanded the eligibility. Previously, let's say for example, if your H-1B stamping has expired and you got the stamping in India, you're going back to India to get the stamping. If it's expired within 12 months, you are eligible for the drop box, so mostly you will get a stamping without any interview. They have expanded the 12 months of after your passport visa expires to 24 months right now. So that's a good thing that they have done. So Dropbox is there, but rest everything is only emergency based. The appointments that are available when I'm looking at it is actually available in February of 2021, sorry.
Harshit from YouTube wants to know, can you file a transfer if you have a pending extension with your current employer and the I-94 is expired? So technically the answer is yes, you can do that, but there's a big risk here, because that basically means that the ability to get the transfer approved is dependent on whether your extension gets approved. Your pending extension becomes a bridge from your expiration of your I-94 to the filing date of your transfer. And if that bridge collapses because either the extension gets denied or the employer withdraws it because you left, that means your transfer is only going to be approved without an I-94. You have to exit the country, get a new visa stamp, and come back. So that's a big risk to take if there's a likelihood that your extension may be denied or withdrawn.
Pranay has this question. If the H-1B is expiring by more than 6 months period, can we file an amendment plus extension? Is there a restriction that you cannot file the extension if the H-1B is expiring by more than 6 months? No. If you're filing for an amendment plus extension, the 6 months rule does not apply. Even if you have 1 year left on H-1B, you can still apply for the extension if it's an amendment plus extension. If it's solely an extension, then at that point of time, the 6 months rule is applicable. Vishnu has this interesting legal question from YouTube. He's asking, where have you seen the immigration or the government, where have you seen the government told you that the number of family spillovers are coming to the employment based? Two things, Vishnu. One, the law. The law is very clear that the spillover for the family-based preference categories have to be given to the employment-based. Oh, this administration is not that good that they'll give it to you, Vishnu. It's only because the law said it. The Congress passed the law. That's the reason this administration doesn't have, they have to give it to the employment-based. If they have a discretion, they won't give it to us, Vishnu. We know them. That's the reason why. Now, the second reason is where we got the figures of between 60 to 110,000. Where did we get the figure? In a meeting with the immigration lawyers, the State Department official who is in charge, Charles, I can't pronounce the last name properly. Oppenheim. Charles Oppenheim. This is a private meeting between the immigration lawyers and the State Department. He has announced it that the spillover amounts are more than 60,000. He hasn't given this specific figure. This, he did it in July, if I recall. So after that, there's August, September, a month are there, and he was actually in the early part of July. That's the reason we came to an estimate. He said more than 60,000 green cards were available that are going to come into family-based green card. That's the reason why all the lawyers are telling that the numbers, and that's the reason why we are telling that the family-based green card spillover has to be given, because that's a law, and there's an official statement given by the State Department. Now, it's a private meeting between the lawyers. They did not publicly announce it, but they announced it in a private meeting. So we are going to get the green cards coming this year, starting from October 1st.
So Roddy from YouTube has an H-1B that was selected in this year's lottery and filed and approved, but has now lost the job in July due to the COVID-19 situation, and wants to know what are the options. So assuming that your employer is not going to withdraw that approved H-1B before October 1st, you can take advantage of the 60-day grace period that will begin on October 1st and file a transfer by November 29th without having the pay stubs from that company. So that would be probably the best option so that you don't lose your cap number.
Shanaz has this question. Can I have a second job on H-1B from a different company, and that is for a part-time H-1B? So that Shanaz wants to work the full-time job and also want to have a part-time job at the side. Yes, you can. It's called concurrent H-1B. You can file a H-1B, second H-1B for a part-time job, absolutely. There's a video that we published recently. I'll try to put a link on the Facebook and YouTube after the session is over, and you can look into that. And that is especially addressing about working for two companies at the same time on H-1B.
AJ from Facebook wants to know, if a person recently transferred from company A to company B, can they transfer to company C, and is there any certain time they need to wait before they can do that? No, there's no set time for that. As long as you've maintained your status with company A or B, you can file a transfer to company C at any time. USCIS doesn't really look into your intentions and filing too many cases too quickly. They're not concerned about that, so no issues with filing another transfer.
Mohammed has this question from Facebook. H4 visa is expiring in 2019. Export visa has expired in 2019. Am I eligible for the drop box in India? If you got the visa in India previously, and you will be eligible to drop box until September of 2021. Previously, it was only for 12 months, but they extended it for 2 years right now. So you will be eligible until September of 2021. But here the condition is that there are some other conditions, but the main condition that I want to put is that you must have got the H4 visa in India. If not, you're not eligible. But if you got it, you're eligible until 2021 September.
Nithi from YouTube wants to know if the priority date becomes current, can we file the adjustment of status without the 485J supplement if the employer is delaying in providing it? I think that's very risky. USCIS is rejecting applications for any silly reason. If you miss one checked box on these 18-page long forms, they will reject the entire thing. I think the 485 supplement J is a mandatory part if you're not filing concurrently with the I-140, and very likely the application would be rejected, so I would not recommend that.
Can I use a previously approved I-140 with company A to file a 485 with the current employer? This is from 1981 from YouTube. The answer is no. You cannot use the I-140 application from the previous company to file adjustment of status with your current company.
Rob from Facebook wants to know, he's got his spouse and daughter's I-539 pending from way back in July of 2019. Their I-94s have expired in September of 2019, still pending because of the biometrics. Are there any issues? So generally, no, as long as the I-539 was properly filed before the status expired. Your family members are in what's called a period of authorized stay, and they're lawfully able to remain in the country the entire time that I-539 remains pending.
A lot of questions are coming out with regards to the third lottery system. Could there be third lottery system? Can I keep the hopes until September 30th of 2020? Well, it's not until September 30th of 2020. You can keep even until September 30th of 2021. I don't know. We projected most probably there will not be a second lottery. We went wrong, which is very good for a lot of people, and which is very good. Could there be? Well, if there are not enough applications and more denials, there is a chance. But what we have noticed, though, Amala from YouTube, is that the denial ratings have gone down very significantly this year as compared to the last year. Even though economy in 2019 was very good, the denials are much lesser this year, even though economy is bad. It's because of the court litigation, what happened, and that's the reason why the USCIS has to back up. But because of that, it's very high. I will be very, would you project a third lottery?
I don't know, because the regulation doesn't even give that as an option. It just says we can conduct a second lottery, but it never says we could conduct a third. So I have a feeling they tried to select enough, but yeah, it'll be interesting.
But it's not September 30th, though. They can even do it after September 30th also, because the year starts on October 1st. It ends on September 30th of next year, which is September 30th of 2021.
Arvind from, I think it was Facebook, wanted to know, he's got an L1 extension pending, and his son is about to start college, and wants to know if he should file the change of status to F1 now or wait for the L1 extension to be approved. Well, if your son's L2 has already expired based on your pending extension, he should wait until he gets the L2 extension approved in order to file the change of status to F1. Even if the L2 has not yet expired, if you file the change of status to F1, the processing time is so long that you're going to need to extend the L2 in the interim, because they're going to keep pushing his start date on the F1 into the future, probably next fall, and he's got to show that he's maintaining the L2 status that entire time.
John has this question: how long it's taking for the labor certifications to get approved? They are adjudicating right now in the May of 2020. Are there any cases pending in April? There are some rare cases pending in April, but most of the April cases are adjudicated. They are right now working in May of 2020. Questions coming on. My employer is telling me that it's going to take about 8 months to file the PERM labor. Is that normal? Yes, that seems to be the normal range, because to get the prevailing wage itself, it's taking 4 months, and to do the recruitment process, yes, that is a normal time to file the PERM. I mean, once they start the process, it may take that long for you to file that.
Ananda from Facebook wants to know if the I-140 was approved a few years ago and not been withdrawn, what are the options to stay in the country if a job loss happens? So if you are in the H-1 status, you know, in a job loss situation, you do have the 60-day grace period. If that is not an option, change of status to B2 may be necessary. And the third option would be the extraordinary circumstances, extreme hardship, I-140 EAD, which is specifically for that type of situation, and our office has actually recently gotten several of those approved for people in that exact situation. It does have some risks because it doesn't provide you with an actual status. It just provides you with employment authorization. So if you later are able to file your adjustment of status, you'd likely have to exit, get a visa, and come back to be eligible for that. But Ryan Wilk is the attorney in our office that's been handling those cases if you want to reach out to him.
Emily, this is from Sandeep. I am getting so much laugh reading it. He's saying, can you be 10,001 time wrong and give an estimation of visa bulletin of EB2? Why don't you give it?
Oh
Emily?
gosh,
because
make
now
me go first.
You'll be much less wrong than I am because I've been practicing law for a longer time than you do in immigration.
I feel like the filing date maybe could go to the end of 2012.
2012?
Maybe. Filing date, I don't know about the final action date.
That's, are you speaking of the October visa bulletin, or are you speaking about by the end of this year?
I'm saying the October visa bulletin filing date chart, which would really be next year.
I'm thinking that it will be somewhere in 2011. That's my expectation. But as you pointed out, Sandeep, I could be, I hope Emily is right. I hope I'm wrong. But anyway, I don't mind getting 10,001 time wrong. Nothing, you know, what can I do? One more. How long it's taking for the premium processing receipt notice to be issued? This question is coming up. We're noticing that, especially in Texas Service Center, there's been a lot of delay in getting the premium processing receipt notices. In some cases, they're taking 14, even 21 days to issue receipt notices right now.
NS from YouTube wants to know, what are the options if an I-485 gets denied to continue the job? I think the biggest question is, did you continue to maintain your non-immigrant status the entire time the 485 was pending? If that is the case, your non-immigrant status remains valid. So if you were in H-1B status and you still have 2 years left on your H-1 approval notice, you can continue in your H-1 status and try to figure out how to fix the 485 issue. If you have let your non-immigrant status lapse, and then your 485 gets denied, then you're in a much tougher situation and have to look at what are the options to file a motion to reopen if that 485 maybe was wrongly denied.
Question that comes from Amarpreet is that how long does the administration take to respond to the RFP submitted? He has submitted in June 30th of 2020, and no response. They don't go by the sequence. This is, you know, they go by each officer will be given a certain load of applications. So if that officer that has your application is backlogged though, and that's where the things will go backlogging more for you. If that officer is quick enough and does the work properly, then you are in a better shape. It depends on the officer, not on the sequence. They don't go by the sequence unless it goes way beyond the time. For example, if your RFP has been done and there's no response for the past 8 months or 6 months, that point of time you can contact the immigration, they'll respond. But if it is responded by June 30th though, the officer is lazy, there is nothing anybody can do right now. One other suggestion that I have is that if your application is eligible for premium processing, don't waste your time, just file the premium processing. That's the best way to solve the problem. There are a lot of rumors saying that the premium processing gets the RFE or denial. That is not true. It's been proven so many times that is not true. It's just a rumor that has no truth in it.
Santosh from YouTube says his employer is planning on revoking his H-1 this month, and his new employer won't be filing a transfer until the middle of next month. He wants to know if that transfer will end up in consular processing. So I mentioned at the beginning when we talked about well, I guess it was in a different video that we're going to be posting.
Yeah.
So keep an eye out for that. We're doing a video on the 60-day grace period, but the timing of the withdrawal of the employer is not relevant. It's does your I-94 have at least 60 days on the end of it? And if yes, then you have the 60-day grace period in order to get the new transfer filed, even if the employer withdraws that approval in between.
Achin has this L1A and I-140 approved, but lost the job. Damn! Can my priority date be preserved? The bad thing is that, hey man, you came very close and you lost the job. The good thing is that if the I-140 has been approved for more than 6 months, and by the time it's not been withdrawn after 6 months, yes, the priority date is preserved for you, Achin. You can use it at any time. If later on you file later on you move to a different company, you can use that. Priority date. And also, let's say for example, you move back to India and then now you got the same job back from the same company. I mean, you can use the same I-140 to file the adjustment of status. There's nothing wrong with it. Yes, that I-140 priority date definitely is preserved. Whether the I-140 is preserved for you depends on if you get the same job with the same company again, then you can still use the same I-140 again.
Imran from Facebook wants to know if there are chances that PERM processing will get faster, as currently it's taking around 150 days. I don't expect it to get faster at this point in time because there's no fee filed for the PERM process. So the Department of Labor has to move analysts and resources around based on what's getting backlogged the most. So when PERM processes start taking longer, then they'll put more analysts on that, but then the prevailing wages will take longer and they move them back and forth. So I wouldn't expect them to get faster. And on top of that, we have a new PERM form that we're going to be required to be using pretty much in the very near future. That may make things a little bit slower as we all get used to that new form.
Well, Swaminathan from Facebook has the question for you, Emily, but I'll answer it though. Let's say Emily's projection comes better. Let's say Emily's projections come because his priority date is June 2012. I wish Emily's becomes current and mine become wrong. If June 12 become current, but I move to a different company, PERM is still pending. What can I do? There is nothing you can do right now. If the PERM is pending with this new company, you cannot file the adjustment of status. You have to wait for the PERM to be approved. Once the PERM is approved, if the priority date still remains current, then at the same time when you file an I-140 application, you can file the adjustment of status when the priority date is current. You don't have to wait for the I-140 approval. Once the PERM is approved, you can do adjustment of status along with the I-140.
Anu from Facebook has a good question that might come up quite a bit this month. If the priority date becomes current next month, can you file the 485 if the H-4 extension for family members is still pending? So yes, you can, especially where the H-1B extension has already been approved and it's, there's nothing that you would expect to cause the H-4 extension to be denied. I think it's relatively safe to proceed with the 485 filing. In the situation where the I-94 has already expired and more than 6 months ago and the extension is still pending and then the extension gets denied, that can be a big problem. So if it's less than 6 months, it's relatively safe. If you are comfortable that the I-539 was filed properly and you already got the H-1 extension approved, so it's just a matter of time for getting the H-4 approved, should be relatively safe, but you can certainly discuss that with your attorney prior to filing the 485.
Anything else, Emily?
Let's see, I think that's about it for today. Thank you for joining us. If we didn't get to your question, remember we do have a free daily conference call. You can go to rnlawgroup.com to get the dial-in for that. And you can always set up an appointment with us or any of our attorneys at that same website, rnlawgroup.com.
Thank you very much for tuning in.